Hey, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have Stephanie Jones updates to the dockets. They're the motions to dismiss the amended counterclaims. We have one document for Jen Abel's counterclaims and one for Justin Baldoni and the rest of Wayfair. So we're going to go through those together. And a reminder, if you can't sit through all this, this is going to be kind of a longer stream. If you can't sit through all this, I'll do a shorter recap in the morning and I'll, as always, post the document link. So I see at least one of you is aware of why I'm late to this stream. Well, let's just say I had a traumatic experience with a bowl of soup in my kitchen earlier, and it was entirely my fault. So, yeah. Let me give people a minute to filter in here, and then we'll start. I've already got these pulled up. So, as always, remember to not take any of this as legal advice because I'm not a lawyer. I'm reading all of these as a layperson. I work in healthcare, primarily in psych. So, I can't give you a whole lot of background on like legal procedures and shit like that. My master's in criminology, but I only have like a basic knowledge of the criminal justice system. So mostly I'm just looking at this as like a random person, just like everybody else who's watching this right now. So we're going to skim over some of the case law stuff because let's be honest, I'm not an expert on that. But yeah. How was dinner? Do you know the answer to that question, or are you trolling me? I don't know. If you don't know the answer to that question, I am not gonna tell you. I've been busy today. Yeah, I have been, bro. It's been a busy week. I miss Omar. We need to get him in here soon. I don't know what he's doing right now. Okay, we'll go through Abel's first. Okay. Oh, good. This lady loves to harp on these text messages. The same text messages over and over. But I mean, what can you expect, really? It's just an amended, or it's a response to an amended. So it's not going to be, doubt we'll see anything mind-boggling in here. So we might get away with skimming through some of it, but we'll see. Give me one sec. Okay. Jennifer Abel's counterclaims are a rotating game of whack-a-mole. Okay. Where the minute one baseless theory is debunked, another even more implausible theory pops up in its place. In her amended counterclaims, Abel abandons 6 of the misguided counterclaims she originally filed against Jones and Jones Works, including the fantastical story that she was falsely imprisoned by her former employer during her termination meeting. Instead, she now claims, even more desperately, that she was hacked by Jonesworks acting as a spy. Oh, God. This new theory... Oh, Jesus Christ. If you don't remember, in the amended counterclaims and she did another amended document, too, that Jones has yet to respond to, but she said that Stephanie Jones had access to her phone up until, what was it, like a few months ago? Including text messages between her and counsel. So, yeah. Anyways, this new theory follows the familiar pattern and has an obvious purpose: to draw attention away from the text messages that she cannot and does not deny she wrote, that form the basis of Jones's well-founded claims against her, for which she has no viable defense. Those text messages conclusively corroborate that Abel brazenly conspired to steal Jonesworks' clients and documents and trash her employer on her way out the door. Okay. Sorry. To make sure that wasn't my mom. Okay, so she, remember that she had put in a bunch of text messages in her original motion to dismiss, and it had all these text messages that were like totally unrelated and just kind of like high school drama type of shit, which is fine by me because I love reading the mess, okay? But as far as like a legal document goes, I don't really think those belonged in there, so we'll have to see what all she includes here. I don't think we're going to see anything new, like I said, but let's see. We got this one from Melissa Nathan to Jennifer Abel. It says, "I know, and once you're gone, we will be on accounts together and make really good money and be happy. And again, let's just keep steering it that way, and you take this fucking client and never talk to her again, I swear to God." Now, The publicist lawsuit is like the only one that I'm kind of like on the fence about. Because to me, it really seems like both of them made some bad moves. Both Jonesworks' side and Jen Abel's side kind of made some bad moves. But you can see that these are obviously taken out of context. So I'm missing a lot of information. And that's what confuses me about this one. But, you know, I'm just here to read the mess. Okay. They reveal that she made no effort to hide her malice against Jonesworks or her plan to go to war with Jonesworks and hold them hostage on her way out the door. I don't know about that. Oh, no, she actually said that. Oh, no. Okay. Jennifer Abel to Melissa Nathan, we are going to war, holding them hostage. Once again, though, taken out of context, I don't know what they were referring to. She could very well be talking about something else. But if she was talking about that, then I concede that was very stupid. And they uncovered that, unsatisfied with only stealing clients, she also set about to steal Jonesworks' confidential documents, even boasting of her ability to evade the security measures the company took to stop her by using hundreds of different emails to infiltrate Jonesworks' systems. Jen Abel to Alicia Jessup here says, yes, pretty much. I have my way around that shit because I have like hundreds of different emails for each domain that I own, so she can suck it. And you can tell Stephanie Jones is really hurt by the she can suck it thing because they constantly bring it up. All right. Indeed, her two-faced and scornful behavior was not just reserved for Jonesworks. Despite publicly hitching her wagon to Baldoni, behind his back, she was trashing him too. So this is where I'm kind of like, what is this doing to prove your point in this legal proceeding? Why did you include this? So again, this is this text from Jennifer Abel we've seen before. It says, I can't stand him. He's so pompous. A men's retreat during release. Is he crazy? And being off the grid for the summer because he's just so overworked. Like, calm down. You're not that important and nobody gives a shit how hard your life is. It's so cringy. So on the one hand, I'm sure that they are putting this in here thinking it makes her look bad. Like, it makes it look like she also thought that Justin Baldoni was like not a great dude. But when you're reading this, like as a third party who I don't know any of these people, and I'm looking at this and I'm thinking, first of all, what does this have to do with your claims against Jennifer Abel or her claims against you, honestly? And second, in context of everything that we know now with the Van Zandt lawsuit, my thought is, I'm looking at these people like, oh my God, you would be willing to kind of do this shady workaround of the legal system and get anyone's private text about their boss that they say in confidence to one of their friends and just put it on blast like this. Like, that doesn't sit right with me. So maybe in a way they think it works for them in like framing her out to be a certain type of person. But at the same time, there are going to be some people, not all, some people who, if they were put on a jury, will see this as like, wow, this is a huge invasion of privacy, knowing everything that we know. In my opinion, that's just how it's going to go. So I can't speak for everyone, obviously, but some people will, have that thought. Okay. His face. I'm not sure what that has to do with anything. Whoa, I cannot speak today. Blake was probably grossed out too. Yeah, and filed a cease and desist. Okay. Even her co-conspirator Nathan could not escape Abel's treachery. Once again, just trying to drive a wedge between these two people who are on the other side of this lawsuit. It has nothing to do with anything that, they're arguing about, really. Somebody else says, Melissa Nathan kind of talks out both sides of her mouth. Jennifer Abel says, you think she's a piece of shit. Okay. Abel's amended counterclaims are only the latest episode in this unbroken chain of fantasy in her quest to rewrite history. Okay, one sec, sorry. Move this. Sorry, I had to fix the sound there. Okay. Okay. I'm going to read that sentence again because that was a lot. Abel's amended counterclaims are only the latest episode in this unbroken chain of fantasy in her quest to rewrite history. But her newest story suffers from the same fundamental flaw as her last. It is not true, and it cannot, in any event, support the newly invented counterclaims she asserts. Each and every one of those counterclaims should be dismissed with prejudice. First, her effort to convert the entirely routine practice of her employer recovering the phone it had provided to her during her employment into a smorgasbord of hacking. I've not seen that word in a while. Of hacking claims fails. The fact is that JonesWorks produced documents recovered from the phone in response to a lawful subpoena. That's highly debated. Which even Abel now accepts. Whoa, 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 whoa. No way. No way. I know that's bullshit. And in any event, Abel herself admits that the phone itself belonged to JonesWorks, that she returned it voluntarily, and that she provided JonesWorks with the passcode to access it. Even Abel's own allegations prove that JonesWorks didn't and couldn't have hacked anything. Didn't and couldn't have hacked anything. I don't know if that holds up grammatically, but I'm just being a cunt. Let me move on. The very circumstances that Abel pleads doom her claims from the outset. Any hypothetical access using credentials Abel voluntarily provided cannot, as a matter of law, be unauthorized. Second, the torts Abel alleges also fail. Not only does New York not even recognize the privacy-based torts Abel tries to allege, but no court anywhere has espoused the theory that Abel advances, that she somehow had a legally recognized reasonable expectation of privacy against her employer in work-related communications made on a company-owned phone. Simply put, Abel had no right to privately use her company phone to undermine and hide things from her employer, conduct a secret business for her own benefit against her employer's interests, and seek to harm her employer's public reputation and private business interests. And JonesWorks did nothing wrong in retrieving that phone when it fired Abel and later producing the documents in response to a subpoena, which revealed, in Abel's own words, in black and white, in text after text, the clear evidence of outrageous misconduct that Abel now stands accused of. For this same reason, Abel's false light claims similarly cannot stick. Abel may wish that the world did not know about her unethical and unlawful acts, but the light that Abel has been cast in is unavoidably true. Lastly, the remainder of Abel's claims are equally infirm. Abel had no property interest in the phone number that she now claims JonesWorks somehow converted. Abel does not actually identify any specific acts that allegedly distressed her and could plausibly meet the extraordinarily high bar required to sustain a claim for infliction of emotional distress. Her promissory fraud claim, too, relies on impermissibly amorphous allegations of unspecified harm. Having been called to account for her actions and having no viable defense, Abel has turned to defense by smokescreen. None of her round 2 counterclaims have legal merit, and the court should dismiss them in their entirety and with prejudice. Okay. Obviously, in those last few paragraphs, what sticks out to me is that whole thing with the subpoena. As we all know by this point, there's a lot of sketchy stuff going on with the subpoena. And it certainly seems to many people, and at this point it is technically just a theory, but I mean, we've all seen the public documents, and then the lawyers, of course, admitted that that was the lawsuit they used to obtain those records. It certainly seems like something nefarious happened there between Stephanie Jones and Leslie Sloan, who called Melissa Nathan the day that they got access to Jennifer Abel's phone and said, "You're going to be sued. I've seen your messages." And then all of a sudden they come up with this anonymous lawsuit with a shell company that had nothing to do with the film or anyone involved, and they're trying to subpoena records for people that violated a contract with this shell company, even though they supposedly don't know who they were contracted with. It just doesn't make any sense to me. But again, I'm not an attorney, so maybe they can stretch and bend that. I don't know. But as a layperson, it seems sketchy as fuck. All right. 1 second, guys. How about says entirely routine. I guess batshit is pretty routine at JonesWorks. I mean, no arguments here from what we've read. Okay. Factual background. Right. I'm going to skim over the stuff that it's like already kind of a no-brainer because we've been over it 1,000 times. Like she started working here, blah, blah, blah. Abel elected to configure the JonesWorks owned phone to access her Apple ID, iCloud accounts, and email accounts. Okay. In 2021, she renegotiated the terms of her employment in exchange for increased compensation. And we've seen all that. Okay. Hold on. Abel also agreed to standard terms commensurate with her position, including that she not steal or divulge company's trade secrets, not compete with Jonesworks while working for the company or for 6 months after leaving, and not try to poach Jonesworks clients or employees. Abel expressly agreed that these covenants were reasonable. So I've seen a lot of people say they don't think that you can have these kind of, like, enforce these kinds of things in California. And, you know, she worked in the California office. So as far as the contractual stuff with the publicist here goes, that's where I get a little confused. And so I'm not going to try to untangle that tonight. We're going to just keep moving. Abel's counterclaims are laden with histrionic complaints about all aspects of her employment at Jonesworks that are both irrelevant and unsupported by reality. Here's what I hate about that, and I think I said this before. When people use the word histrionic to just mean dramatic, it irritates me. Histrionic is very different than just being a little dramatic. And also, these people keep calling each other back and forth histrionic as if that word is going to change anything. Like, just make your point. You don't have to be a drama queen about it. You don't have to be a histrionic queen about it, okay? You know, they're not the same thing. But that's just me being nitpicky, because histrionic and, like, terms like that are very specific to certain personality disorders and certain behaviors. So I obviously get choked up on that. So that irritates me a little bit. It's just a pet peeve. Abel worked at the company for more than 4 years, never voicing her concerns that she now claims in this latest version of her revisionist history. Okay. Sorry. Just trying to skim over some of this real quick. Only further confirming her opportunistic effort to rewrite history and shift her narrative when the facts are no longer convenient, she excised from her amended counterclaims her previously pled admission that she thought highly of Jones up to the time of her prospective departure. Honestly, I didn't even notice that was gone. I don't really know that that means anything significant, but I'm sure that hurt her feelings. Okay. In July 2024, Abel informed Jones of her intent to leave. At first, the planned departure was amicable, as Jonesworks arranged for Abel's transition, and Abel made logistical arrangements, including, for the first time, asking that her phone number be released from the company's account. But in mid-August 2024, Jonesworks learned, after inquiring into suspicious file transfers on its computer systems, that Abel had been downloading dozens of proprietary documents from the company's systems to her personal laptop, which she had no reason or authorization to access, let alone surreptitiously misappropriate. So that is where I'm kind of concerned, like, she might have fucked up there. She might have done something wrong there. But I can't say that for sure, because I don't know. I don't even know if they're applying New York or California law here, for one. And second, I don't know exactly what the terms, sorry, I'm trying to find my glasses, bro. What the terms of the contracts would allow, and whether or not what she's saying is, improper, is actually enforceable in California if that's what they decide to use. So that's just a whole clusterfuck for me. But I guess before the trial, obviously they'll know which law is going to apply, and that will help a little bit, because that way I can kind of work out what standards we're applying, because this shit is a little nutty. Okay. To terminate Abel, Jonesworks took the common and reasonable step of requesting that she meet with its legal counsel and chief of staff, asked to review the personal laptop that she had been using for company business and used to download Jonesworks documents, and asked her to sign termination forms. Okay, so I guess she agreed in writing to let them review the personal laptop. Okay. Termination forms included, they claim she falsely signed what do you mean falsely signed? A statement that she had not retained any Jonesworks documents despite plain forensic evidence proving that she had been emailing documents to herself weeks before her termination. So if that is true, and everything we've read so far, if that's true, then yeah, she's kind of fucked. But that has nothing to do with Blake Lively's complaints and that side of the lawsuits and like the sexual harassment claims and stuff like that. It has nothing to do with Justin Baldoni and his claims of, the extortion plot and all that. This is just what we're reading right now is just relating to Jennifer Abel and Stephanie Jones. So keep that in mind. So a negative outcome here really doesn't affect too much about the other cases or they're not even the same, I guess, docket or whatever, but the other complaints. Okay. Abel incoherently and fantastically characterizes that this attorney asking her to sign termination paperwork as coercion and threats that allegedly placed her under extreme duress and tries to disavow the consequences of her voluntary compliance and signature on documents. Okay. At the conclusion of the meeting, Abel alleges that JonesWorks' chief of staff asked her to return her company-owned phone, which she did, and asked her for the passcode to that phone, which she provided without question. Text messages downloaded to Abel's company phone revealed that Abel had been spearheading a campaign to retaliate against Lively for allegations of sexual harassment against Baldoni, and also instigated a campaign of destruction and disparagement against Jones herself. Abel now alleges that JonesWorks' production of those text messages was unlawful and invaded her privacy. Well, like I said, the subpoena in question was it's pretty sketchy right now. And then also the text messages that she's referencing here, it's interesting that she doesn't feel the need to cite them specifically, even though she wanted to include those kind of gossipy texts in the beginning of this document. Yeah, that's a bit odd to me, but and also those these kind of vague claims are important because those text messages, to me, from my standpoint, when I read them, just showed like a kind of a defense strategy. So like if they start going after Justin and Wayfair in the press, because it certainly looked like that was about to happen and ultimately it did. That is the strategy they would use to kind of protect his reputation and protect the success of the film and, like not have it overrun by bad press about what happened between the cast and all that. Ultimately, that failed. But, I didn't get any sort of feeling that they were trying to actively disparage anyone, even with Stephanie Jones in that article that she's citing, that they tried to like smear her or whatever. It seems like a journalist reached out to her. She talked to the journalist, whatever, but it didn't say that she said anything negative. It didn't say that she really provided her any information, just that the journalist had contacted her. To the best of my recollection, that's all that we saw, so I don't necessarily think that this is a very convincing sort of paragraph here, but that's just me. Okay. Furthermore, despite baseless hypotheticals that JonesWorks could access her personal communications, Abel identifies no personal information whatsoever that was allegedly revealed in violation of any conceivable privacy rights. Instead, she complains that text messages revealed her misconduct in participating in an unlawful retaliation campaign during her employment, but behind the back of her employer. Yeah, so that never happened. That's not what was said. I mean, that's not even smoke and mirrors at this point. It's just like completely see-through. That's bullshit. So I don't even really know what to say to that. Okay. Legal standard is where we're going to start to skim. Because like I said, I don't have a lot to offer you guys in regards to case law and those kinds of things. So give me 1 second. I love the long streams. Thank you. Well, thank you, Ashlyn. I appreciate you watching them. Let me get through these and then we'll get back to this. Ricardo, thank you for the 2. Hello, lovelies. What did I miss? Nothing yet, bro. Well, you did miss the soup thing, but honestly, you're better for it. All right. Michelle, thank you for the 7. Pacer fun. Thank you, Lauren. I appreciate you. Thank you very much. Ricardo, thank you for the 5. Lies, the forensic investigator found nothing on her laptop twice, plus she does have reasonable expectation of privacy when previously agreed to. This is where I get really confused, man. But I hear what you're saying. Because we're hearing two conflicting stories here. And so I'm kind of like, my mind, they're playing ping pong with my brain on these. Whereas with Justin's filings, it's like a little more clear cut to me because they've shown exactly where each claim of Blake's fails. So it's with this one, it's, I don't know, they were a little more vague in that. So, but no, I hear what you're saying. Thank you. Appreciate it. Jennifer, thank you for the $50. Jesus, that's generous. Thank you very much. I appreciate it. I love listening to your insightful commentary interspersed with your adorable giggle. Oh, I don't know about that, but thank you. Thank you for the brilliant coverage. Thank you for watching. I appreciate you. You guys are awesome. Thank you. All right, let me get back to it here. We're going to skim over that. Abel's implausible and vague allegations fail Rule 8 standards. Her allegations of hacking are wholly vague and conclusory and fail even the most lenient Rule 8 standards as a matter of law. For example, she alleges in wholly conclusory and unsupported fashion that JonesWorks bypassed the password protection on her accounts. Did she say that? I don't know that she actually said that. I don't know. How? Using what technological means? In what circumstances? Hey, why are you asking me, bro? All right. She similarly alleges that JonesWorks was monitoring and intercepting her private communications in real time. Well, that could certainly be true, to be honest. But again, how, when, which communications, and what is her basis for believing or alleging this? These wholly... You sound confused. So am I now. These wholly conclusory assertions are utterly devoid of any factual corroboration or grounding as required by Rule 8. Okay. And based on what she observed or otherwise supported facts. Why are you asking so many questions? I came to you for answers. What the fuck? All right. We're moving on. In similar vein, Abel conclusory alleges that JonesWorks accessed protected computers knowingly and without authorization or consent, or in a matter that exceeded their authorization. This again is a conclusion of law and recitation of a statutory element, not an alleged factual basis for her claim. And further, which is it? No, again with the questions. And how did the company that owned the phone lack authorization to use it? Please stop asking me questions. Ricardo's so passionate about this. I love it. Yeah, no, he is. Okay. No, she said she gave her passcode for specific use. Okay. I gotcha. All right. Well, since I don't have the answer to their question here, why don't we move on? Oh, no, more questions. Okay. We're getting into the CFAA. Hang on. Access under CFAA requires accessing a part of the system to which the person did not have access. And how did Jones allegedly overcome generally applicable rules regarding access to those computers? What even were those rules? And how could JonesWorks possibly overcome? Oh my God. Is this an interrogation? How could JonesWorks possibly overcome rules simply by using a passcode that Abel admits she provided to it? All right. Abel's allegations of harm are equally conclusory and often incoherent. She alleges that she suffered enormous harm to her personal and professional life. Suffered harm, suffered damages, suffered harm and injury. Okay. Or in one of her multiplicity of claims, alleges nothing about harm at all. This is facially deficient. Facially deficient. That is not something I've heard before. Facially deficient. I'm going to find a way to use that. Abel must make factual, non-conclusory allegations stating a plausible claim that defendant's conduct caused specific harm. Okay. She has not done so, so her claims fail. B, to the extent Abel alleges any conduct by JonesWorks at all, those alleged acts did not violate any of the alleged statutes. Abel also fails to plausibly allege that JonesWorks engaged in the specific conduct prohibited or required by the applicable statutes to state a claim. The CFAA requires that a person use illicit means to circumvent some gate controlling access to a computer. All right. The SCA requires that the defendant accessed an electronic communication service or obtained an electronic communication while it is still in electronic storage without authorization. The Wiretap Act prohibits intentional acts to intercept communications in flight and does not apply to an electronic communication that has already been delivered. Okay. In California Penal Code Section 502 only applies when a party circumvents technical or code-based barriers in place to restrict or bar a user's access. Abel's allegations fail to allege any such conduct. Indeed, courts have flatly rejected the theories of liability attempted here. For example, we're going to skim over this case law. All right. With respect to the Wiretap Act, the court concluded that the text messages appeared on his company iPhone. We're still talking about that. Hold on. Yeah. The employee's Section 502 claim also failed because the employee's fact-barren and vague allegations, which closely resemble Abel's allegations, are precisely the type of threadbare recitals prescribed by Twombly and Iqbal. All right. C. Abel's claims fail numerous additional statutory requirements. She separately fails to plausibly allege facts to satisfy multiple other requirements of applicable statutes, each of which provides an independent basis for dismissal. 1, her alleged harms are not cognizable under the CFAA. All right. 2, messages on the iPhone are not in electronic storage under the SCA. 3, Abel alleges no plausible intent to defraud. Well, that's, I don't know about that. 4, Abel does not plausibly allege any jurisdictional nexus to California. Again, I don't know about that. 5, Abel's jumbled statutory copy and paste fails under Section 502. Well, why don't you just be a bitch about it? Jesus. One sec. Thought that was my mom. Okay. Answer your mom's text, people. I'll stop what I'm doing. All right. To plead as broadly and vaguely as possible, Abel copies and pastes miscellaneous words from Section 502, alleging that JonesWorks violated the statute by knowingly and without permission accessing and causing to be accessed, taking and causing to be taken, copying and causing to be copied, using and causing to be used, computer services. This compromises nothing more than a jumbled recitation of words taken from different subsections of Section 502C with no seeming rationale. Well, I would love to rebut that. But if you know, you know. And what I mean by that is I can't read a can of soup, apparently. So moving on. Okay. 6, Abel fails to plausibly allege that JonesWorks intercepted any messages. The Wiretap Act only prohibits intercepting communications while they are in flight before they are delivered to the recipient's encounter device. She makes no such allegations, instead alleging falsely and in conclusory fashion that JonesWorks viewed messages after they arrived in her iCloud or email accounts. Okay. Abel's tort claims must be dismissed. A, she cannot claim invasion of privacy based on work text on a work phone. Okay. Well, I think they'll probably argue that a lot of these were not work texts. That's just my guess, but Abel's, well, not Jones, but Abel would probably argue that a lot of that there was not work communications. You know, Abel's invasion of privacy claims, counterclaims 5 and 6, fail on their face. New York does not recognize common law privacy tort claims, including specifically the 2 claims Abel brings here: intrusion upon seclusion and false light. Okay. Abel admits that she voluntarily transferred her phone number to JonesWorks upon hiring, and that her newly issued device with that phone number was a company-owned and controlled iPhone. As a matter of well-settled law, Abel enjoyed no reasonable expectation of privacy in the contents of that company phone. Abel's conclusory allegation that she had a reasonable expectation of privacy is of no moment because, one, she had no such expectation in a work phone, and two, this is a legal conclusion masquerading as factual allegations, which is routinely rejected. Abel admits that the phone was owned by and returned to JonesWorks and used by Abel in the course of her employment, which renders her bald allegation that the phone and data at issue were personal nonsensical. Because both of Abel's invasion of privacy claims relate exclusively to the contents of a company-owned phone, in which she enjoyed no reasonable expectation of privacy, her claims fail. Second, Abel fails to allege that JonesWorks acted in any way that was highly offensive invasion of that privacy or an egregious breach of social norms. Well, you want to talk about egregious breach of social norms? I don't know about this specific topic here, but I remember a lot of the stuff they wrote in that amended counterclaim, and there were some interesting breaches of social norms in it. All right. The vast majority of Abel's newly fabricated allegations are nothing more than conclusory speculation that this court should disregard. Her allegation that JonesWorks could read her communications with her fiance, parents, friends, everyone, notably does not allege any facts, because there are none, to support a conclusion that it ever did. Likewise, Abel's bald allegation that JonesWorks had been intercepting and monitoring all of her text exchanges lacks any specific or purported basis that could tip it into plausibility, including by not identifying a single supposedly monitored or intercepted message. Abel's complaint's core grievances include her allegation that JonesWorks provided information to third parties concerning Abel's unlawful actions on behalf of Baldoni, including allegedly to the targets of those unlawful actions. But these allegations relate, at best, to messages she sent and received regarding an illegal harassment and retaliation campaign undertaken during Abel's employment on her phone. Okay. Work phone. Okay. Again, none of what she alleges is Abel's personal information, nor does it rise anywhere near the level of highly offensive or egregious that would meet the required standard. All right. Third, Abel's false light claim fails because she does not allege any false or misleading disclosures. She throws a single allegation at the wall. Jones and JonesWorks publicly disclosed information or material regarding Abel's moral character and personal and professional life, which showed Abel in a false light. This merely parrots the tort and is insufficient. Let me see what's going on with the footnotes here. As detailed in JonesWorks' motion to dismiss the counterclaims brought by Wayfair Studios, any such disclosure would also be protected by the Speak Out Act. I fucking hate when they cite that. Through which Congress confirmed a strong public policy in favor of encouraging and protecting the disclosure of information related to sexual harassment. Yeah, so, like I said, I'm not a lawyer, but as just a layperson reading this, I get irritated when they cite that, because I'm like, there is actually no evidence at all of any sort of sexual harassment. And I strongly believe that they misrepresented the facts and exploited the experience of a lot of people who have been sexually harassed in the industry. So they say here, any disclosure in furtherance of such public policy cannot be considered highly offensive, but it is. It is highly offensive. And I'm not the only one who feels that way. But all will come out in due time. So, all right. Abel's complaints appear to be not that anything false was said about her, but rather that JonesWorks allegedly revealed Abel's own words to Sloan and Lively. Well, when it comes to privacy and stuff like that, that's kind of important. All right. Far from portraying her in a false light, the publication of her own texts in her own words has painted her in the truth. Her privacy counterclaim should be dismissed. Okay, well, hang on. The publication of her own text messages in her own words has painted her in the truth. Man, we all say shit about our bosses and people that we work with in text messages and whatever. I don't care. You can't tell me there's really anyone who's never said anything about like being annoyed or irritated with a coworker. I don't know anybody who's never been, feeling an emotion and in the moment said something that they didn't really mean in a general, like generally they didn't really mean that. Even if they really liked working with that person, we all get on each other's nerves. It's going to happen. But you should be able to trust that if you're sending a private message to a friend about it and just blowing off steam, like that shouldn't be blasted in a fucking New York Times article. So that's just my opinion. All right. JonesWorks cannot convert something Abel never owned and voluntarily transferred. Okay. I mean, that's pretty straightforward, I think. So we don't need to go through all the case stuff here. Not that they're necessarily correct. I'm just saying the claim is pretty straightforward. Her claim fails to meet two other elements. That she voluntarily transferred the phone number to a phone owned by JonesWorks and to JonesWorks' phone plan. Even crediting her allegations, she nowhere offers any plausible basis to conclude that JonesWorks retaining the phone number she had transferred was conversion. C. Abel's distress, if any, arises from being caught red-handed and does not give rise to tort claims. I mean, look. Thinking about how these messages were obtained and the way they were used in the aftermath. An appropriate, like, assuming they got this through means that were not nefarious. An appropriate punishment to me seems like, oh, the person I was talking about should be mad at me. Like I'm not thinking that they deserve to be dragged through the court system and punished like that for private messages they sent to a friend. That being said, I don't think it was the smartest thing in the world to combine her work and personal, life into one phone. But I don't know. I don't think she was necessarily caught red-handed so much as I think that her boss was extremely paranoid given the behavior that's been described, and then went along with this, or like even devised this stupid plot to like give the other side of this lawsuit her messages, or like tell them at least the nature of what was being said, that they could come up with a way to obtain these messages. And there was like a really roundabout, sketchy way of obtaining them. I don't know if I would really call that being caught red-handed. And again, I don't really think that she deserves to have her messages about her boss paraded through the New York Times. I just don't feel like that's right. But again, that's not a legal perspective. That's not a legal opinion. That's just a personal opinion. So I don't know. One sec. Okay. C. Abel's distress, if any, arises from being caught red-handed. That we just talked about that. Abel's emotional distress claims are equally deficient because they fail to allege the required elements of severe emotional distress and extreme and outrageous conduct. 1, she fails to allege legally cognizable severe emotional distress. Let's go over that. Abel's rambling allegations, albeit hyperbolic, cannot meet this standard. She complains of certain alleged working conditions at JonesWorks, including Jones calling at late hours and reprimanding Abel in front of other employees. Okay. Despite conceding that she remained working there for more than 4 years. Okay. In the footnote here, number 9, it says Abel conspicuously deleted evidence quoted in her original counterclaims, admitting that she wrote to Jones before her departure, "I respect you immensely. I feel so grateful for the opportunities you have given me with your premier clients and how you have lifted me up as your partner." Dude, I don't understand why that's such a big deal. I don't. Sorry. Am I missing something? Like, why is that such a big deal? She complains of being abruptly terminated by JonesWorks and that the manner of her termination, conceitedly being asked to meet in a conference room with employment counsel and JonesWorks chief of staff, sign paperwork, and leave, caused her to dissociate and fall into a state of shock. And she complains of the inconvenience of losing access to her mobile phone number. Whoa, hold on. No, isn't her father in like an assisted living facility or something like that? That's far more than an inconvenience. So maybe go fuck yourself on that one. I don't know. That's where you lost me. Like, I'm trying to be kind of fair, but no, if that's actually what's going on here, like if she was complaining about having legitimate issues accessing contact information necessary to like oversee the care of her father, or do other stuff that's necessary for her day-to-day life activities, then you're kind of a cunt for that. So I can't tell you what a lawyer would say about that claim. I can only tell you what a layperson would say about that, and not any layperson, me specifically. And what I think is you're being kind of a cunt for that. Yeah. Okay. And she complains of the inconvenience of losing access to her mobile phone number, as well as certain accounts and contacts for a short time. Even the most permissive light, these allegations cannot sustain her claims. All right. Worry, anxiety, upset stomach, concern, and agitation are not severe emotional distress. Her conclusory allegations that she suffered severe or extreme emotional distress and mental anguish cannot save the failure to specifically plead such distress. 2, Abel alleges no extreme or outrageous conduct. Well, that, on its face, does not seem true. Okay. Intentional infliction of emotional distress claims are highly disfavored under New York law, and in any event require extreme and outrageous conduct under both New York and California law. I disagree that she didn't allege any extreme or outrageous conduct. But all right. Abel does not allege any such extreme and outrageous conduct that would be sufficient to meet this threshold. Indeed, she does not allege any specific identifiable conduct in support of this claim at all. Instead, she only vaguely invokes the misconduct of Jones and Jones Works and its officers, directors, employees, and agents. This alone justifies dismissal. Even the supposed misconduct that Abel does allege does not approach the required threshold. Her allegations at most describe her after-the-fact discomfort with Jones' management style, under which Abel worked for 4 years, reaping ever-increasing rewards. The law affirmatively excludes much of this complained of conduct from forming the basis for emotional distress claims. Abel's nonsensical allegation that Jones worked counsel asking her to sign documents was coercion and threats cannot save this claim. So I wonder if she ever tried to complain about Stephanie Jones' conduct while she was working there. I'm going to say no, probably not, because it's Jones Works. So, that's intimidating enough. But it sounds like they did not have any kind of HR department, really. So it wasn't like a huge firm. I remember they described the office having a pretty small number of employees. So I'm curious as to whether or not she ever tried to breach that subject, especially after Stephanie Jones had, told her or whatever that her psychic said she was going to be having twins, and like she was struggling with infertility at the time. So that was a really obviously bad thing to say. I don't know. There's a lot going on there. Whether or not it falls into the parameters of this lawsuit, I don't know. All I know for sure is that put a bad taste in my mouth, personally. So, all right. And he says, I'm getting annoyed with YouTube. It didn't notify me you're live. Yeah, I don't know what's going on with that, man. YouTube notifications are pretty ass. But thanks for being here. Okay. 3, Abel's negligence-based claim fails because she alleges no negligence nor specific breach of duty. Okay. Negligent infliction of emotional distress under both New York and California law is premised on the breach of duty owed to a plaintiff. Again, whoa. Again, Abel superficially recites the elements of this claim, but makes no specific allegation of what conduct by Jones or Jones Works allegedly breached any duty owed by them as her employers, and how. Much less does she allege any breach that either unreasonably endangered her physical safety or caused her to fear for her physical safety. Her failure to allege the required elements of this claim with specificity dooms it to failure. Okay. We have a footnote 10 here that I missed, and this was regarding the emotional distress claims. The footnote 10 says Abel does no more than sling baseless, disparaging allegations about Jones' sleep schedule. Jones vindicated concern about Abel stealing clients and magically transforms a tarot card reader at a Jonesworks office party into an alleged psychic. Okay, well, if that's true that it was a tarot card reader, it is still wildly inappropriate to tell your employee who's been struggling with infertility issues that she's going to be having twins because your tarot card reader told you so. That's fucked. So I don't care what term you use or what it was, a tarot card reader or a psychic, it's fucked up. So that's not exactly baseless in my opinion, but from a legal perspective, maybe somebody else might think that it is, but from a personal perspective, just as a human being, that is appalling. That is absolutely appalling and inappropriate. Okay. Further, a claim for negligent infliction cannot be premised on intentional conduct. Yet that is what Abel alleges. Jones and Jonesworks intended to cause Abel emotional distress, and they're quoting the amended counterclaims. Let's see. Abel's undisciplined, throw everything at the wall approach should not be permitted. She has failed to specifically plead any required element of intentional infliction of emotional distress, and a hand-waving claim of negligence, irreconcilable with intent, cannot mask her failure. These claims should be dismissed. Okay. Sorry, I thought somebody said something about the tarot card thing in here, but maybe I made that up. Panda Bear. Unless the reading was on Jones herself of the tarot card reading. Yeah, I mean that's one thing. If that's that's your thing, that's fine. But the allegation is that Stephanie Jones told Jennifer Abel, who is struggling with fertility issues, that Stephanie Jones's tarot card reader said that Jennifer Abel would be getting pregnant with twins or something like that. Something of that nature. Something wildly inappropriate, which is nuts. Okay. So, if that's your thing, cool. Like, I don't judge. I don't totally get it with like tarot cards and astrology and all that shit. Like, I don't get it. It's not my thing, but if that's your thing, cool. No judgment. I just don't understand. But if you try to kind of force that on your employee in an appropriate context, especially regarding a ongoing medical condition, that's a big yikes. Big yikes. So, all right. Abel's fraud claim fails in every possible way. All right. A claim for promissory fraud requires 1, a material false promise, 2, made with knowledge of its falsity, 3, an intent to defraud or deceive, 4, that plaintiff reasonably relied upon, 5, causing damages. Once again, Abel fabricates a new set of facts in her desperation to save counterclaim 10 and still fails. Abandoning her original allegation that Jonesworks supposedly induced her to port her phone number to a Jonesworks phone in 2020 by promising her in 2024 that she would retain possession of the actual phone number, Abel now alleges that Jonesworks fraudulently induced her to return its property when its chief of staff promised Abel that if she gave up her Jonesworks issued phone and provided her passcode, Jonesworks would release her number. Abel cannot offer different and inconsistent facts to plead around her failure to properly state a cause of action for promissory fraud at the outset. Put another way, Abel alleges that she declined to steal Jonesworks' property by refusing to return it on request. Deciding not to commit a crime is not legally cognizable reliance? So I don't understand. Yeah, I don't get it, guys. I'm not gonna lie to you. I don't get it. Any reason to need to induce her to return it? She alleges that she declined to steal Jonesworks property by refusing to return it on request. What I'm not understanding here is, like, so she's saying that the number was hers, which it was. It's a number she had since she was in high school. And she agreed that the device itself was Jonesworks property, but upon any kind of termination or separation, whatever, they were supposed to release the phone number. They could just have the phone itself back. So this statement alleges that she declined to steal Jonesworks property by refusing to return it on request. I don't get it. I'm going to need Omar to explain it to me tomorrow. Or, yeah, I don't know what he's doing tonight, but we'll see. Abel also must, but has not, set out specific facts in her complaint demonstrating that defendants never intended to make good on any of the promises made. All right, we're going to skim. Finally, Abel's generic claim that she was harmed is insufficient for lacking any nexus between defendants' alleged misrepresentations and her losses. Conclusion: plaintiffs respectfully request the court that the court dismiss Abel's amended counterclaims in their entirety with prejudice. Okay. And then we have the one against Wayfair here. So this is, again, another motion to dismiss counterclaims. Somebody says, astrology and religion are intertwined, and some people have negative religious views about it, so talking about it in the workplace is inappropriate. I agree with that. I mean, there's lots of stuff that I feel like is just not appropriate for the work setting. And I've even gone so far as to say, like, any sort of prayer or meditation or whatever on the set of the film should have been done. And I'm not saying that it wasn't. I'm just saying if that was actually a thing that was a problem, should have been done, only with people who willingly agreed to that, and maybe not around people who seem like they may have been unsure. But, I don't know exactly what happened. I only know what's been alleged. So, okay. Let's see. Oh. Somebody says the weather's good in Melbourne. I'm going to be in Melbourne in a month, bro. Well, no, I'm going to Sydney first. So I'm going to see Omar. I'm stopping in LA. So I'll be working remotely in LA for a couple days. And then I fly to Sydney for Vivid, because I haven't been there for Vivid, and I'm super psyched about that. And then I'm going to Melbourne from there. So that'll be good. So I'll be there in a little over a month. It'll be cool. I'm happy about it. I've been there before. This will be my 5th trip to Australia in the last couple years, actually. I go there for this thing called WentworthCon. That's my favorite TV show. It's an Australian women's prison drama, so go figure. But yeah, I go out there for that. And I make a lot of the show reels, edit those and stuff like that. So it's pretty fun. Yeah. All right. Anyways, let's get into the Wayfair thing here. And this is, again, Stephanie Jones' motion to dismiss their amended counterclaims. Wayfair's amended counterclaims are, like their predecessors, devoid of any footing in law or reality, and serve only as a transparent vehicle to vent Wayfair's anger over the lawful exposure of its co-founder Justin Baldoni's sexual harassment of co-star Blake Lively and his and Wayfair's run-on sentence, and his and Wayfair's retaliatory, vindictive smear campaign that followed. Irate not at Baldoni's wrongdoing, but that it was widely covered in the press, Wayfair now seeks to punish Jonesworks and its founder, Stephanie Jones, masking lawful process with defamatory cries of leaks. There were no leaks. Oh, let's pack it up and go home then. You said it. And Wayfair is not a victim. Instead, it was a principal actor, not only in a lively campaign, but also in a covert, calculated scheme to sabotage Jonesworks from within and flout irrefutably plain contractual commitments. Wayfair's amended counterclaims fare no better than their first attempt, falling far short of stating any viable claim for relief. So, here's the problem. With all of this smear campaign bullshit, covert smear campaign, I don't even know what to call it, man. With all of this bullshit, it's like these people who work in fucking PR haven't been on the internet in a decade. Because anyone who spent any time online knows that these days celebrities, especially when they do something that people don't like. Celebrities are having their histories, their past interviews, their bad behavior that they've talked about before. It's all being dug up and put out there way more than ever before. I mean, it happens to everyone. Politicians, movie stars, fucking YouTubers. YouTubers, man. Like, come on. Like, everyone's doing that all the time. And it just so happens that Blake Lively and Stephanie Jones have a long history of acting like a bunch of bitches. So, like, what do you expect? So they're trying to say this was inorganic and it was some kind of calculated scheme to make them look bad. But the truth is, because it even happens to me, bro. And like, I'm like a small channel, right? And I just sit here and I talk about court documents. But it even happens to me. Like, people will go and write rude comments about me for stuff I said like months ago. And even if it doesn't mean what they're claiming that it means, right? And I think people have probably seen me while I'm on my learning curve of how to handle that. It literally happens to any sort of public figure. Because there is always going to be someone who doesn't like you. And with that someone is 5 or 6 of their friends. And they're going to find something that they don't like, or they're going to find something that they can twist into something that they don't like. And they're going to use that. And then more and more people are going to catch on. It's just, that's the name of the game these days. I hate it. I hate it. And I try not to judge people on stuff that happened like 10 fucking years ago, because even like, if you go back to the first stream I ever did on these court cases, the first thing I ever read was Blake's complaint. And one of the first things I said was, I don't want to judge this person on stuff that they said such a long time ago, because I think that we all change a lot. I think that we all grow a lot. The problem lies with people who have not learned their lesson, people who have not tried to do better, and people who are still acting, I don't even want to say unprofessionally, that's not the word, acting like a bunch of bitches. That's the best way I can put it. So if you're still acting like that, then I think that's kind of fair game, and that's kind of how it goes, right? So I don't judge these people like on a lot of stuff in the past. Like, you'll see a lot of stuff that makes headlines that I don't cover. I mostly stick to court stuff, because I'm like, I don't want to be judged on stuff that I said when I was 21, 22, or younger than that. So I don't do it to other people, even people I don't like. But the reason I've kind of thrown all that to the wind is that they're claiming that there was some inauthentic campaign to make them look bad, when the truth is, people just don't like you because of who you are and who you've been recently. And they found evidence to back that up and to further reinforce those beliefs and those opinions based on things you've said in the past. So it appears you have not changed. That's the problem. So you might get a handful of people on the one hand, like if they don't like you, you might get a handful of people who like dig up and find stuff and say all kinds of things. If you are a decent person and you're a high profile public figure and stuff like that, no matter what, even if you're a decent person, you're going to get people like that. But if you are acting like this and making false claims like this, then yeah, more and more people are going to jump on that bandwagon, and they're going to find out what you said in your past, and they're going to show, hey, look, this person is still acting like this today, and you're going to get fucked over for it. And that's your fault. I'm sorry. It is your fault because you did those things. You are doing those things, right? So I don't know if this is making any sense, but they're trying to make it seem like this was some inauthentic smear campaign, when the truth is, people don't like what you're doing. People don't like what you're putting down. And you got to change something. Otherwise, they're going to keep bringing up the stuff you've done in your past. Because everybody likes an underdog story. Everybody likes a comeback story. If you were like, did something 10 years ago that was kind of shitty, and you've worked on that and you've done better in the present, then you're going to have a lot more people coming to your defense and being like, hey, like, this is not who this person is anymore. They were really young when they said that. They were really stupid when they said that, but they, have come out and have since, for example, if you got married on a plantation, maybe you do some actual activism or do some actual work to show that you would not make that choice in the future. That's what you have to do to change that. But if you haven't done that, that's when you have all this organic backlash, because people are more obsessive than ever on the internet. more obsessive than ever about deep diving into people's history. I'm not excluded from that, all right? I don't do a lot of that, but I'm not excluded from it. Like, I like to read the mess as much as anyone else, but this is just so annoying because they're saying, like, there's this covert calculated scheme when the truth is you put it all out there just by being a bitch. So, like, that's not anyone else's fault but your own. And I'm word salading. I know that I am. But I don't know. I just have a lot of feelings about that, I guess, to be honest. So, one second. Somebody says, I didn't think people still used Facebook. Man, I use Facebook because Facebook was around when I was young. It was like the first thing that really connected people online and shit like that. And so I remember it was like just for college kids when it first came out. But my cousin and I, we were in like middle school. And we were like, we want to be cool. We want to be on Facebook. So I've had my Facebook account since like 2005 or something, or 2006, something around then. So I'll never get rid of it unless I get banned, which is not out of the question, to put it lightly. So, okay. Facebook is for family. I agree with that. I agree with that. Okay. Anyways, moving on. A lot of this is going to be the same as like what we saw in the Able complaint, probably. So I'll skim over that when we get to those points. Okay. Wayfair's breach of contract counterclaim primarily rests on specious allegations that Jones and Jones Works improperly divulged confidential information. This fails on numerous fronts. First, confidential information, as defined in the agreement, excludes information which is or later becomes publicly available through no wrongful act of company. Whoa, sorry about that. So through no wrongful act of company there seems like a pretty big point. But okay. That is precisely what happened here. Information was produced and made public pursuant to a lawful subpoena. Here we go again, bro. Which, after months of cries of phantom subpoenas, even Wayfair finally accepts. Whoa, nobody said they are accepting that narrative, because there's no reason to think that this was a lawful subpoena at this point, because you can't go sue John Doe's 1 through 10 and get their information when you know exactly who you're suing, and you're just using John Doe to skirt around the notification part of this. No judge ever signed off on it. Nothing. And Stephanie Jones handed that shit over because she knew she could get away with it, because no judge signed off of it on it, because nobody was going to get a chance to fight it. So that's, again, just my opinion. People don't like you because of who you are. That hurts. I mean, bro, it's true. If you go in and get yourself married on a plantation and then make a, oh shit, I'm sorry donation several years later, and then you're on the Time 100 list for it, for being an influential person that year, 6 years after you made that oh shit donation. I mean, people don't like you because of who you are. That's just the goddamn truth. Because you're transparently a piece of shit at that point. That's just me. All right. First, confidential information, as defined in the agreement, excludes information which is or later becomes publicly available through no wrongful act of the company. That is precisely what happened here. Okay. Second, Wayfair alleges that the information produced was Abel's private communications, not Wayfair confidential information, which is self-defeating of Wayfair's breach of contract claim. All right. I'm looking at the footnote here just to see. Talking about the expectation of privacy again. Okay. Third, Wayfair's false allegations are hopelessly vague. I'm getting a little defensive here, guys. Failing to identify. I'm honest. I'm biased. I'm honest about that, right? I'm a little biased here because I want Wayfair to win their lawsuit. So you got to take my reactions with a little grain of salt. But I'm honest about that. So failing to identify any purported confidential information with any specificity. This lack of detail is for good reason, as under no construction can information exposing in vindictive sexual harassment and retaliation conspiracy constitute Wayfair information subject to protection. Oh, well, there was no vindictive sexual harassment and retaliation conspiracy, so you can go fuck yourself. Jesus. There are things I can't say right now that I would love to say, but I can't. And like I said, all will come out in time, but it's not my place. Finally, Wayfair's amended counterclaims attempt to wield the confidentiality provision of the services agreement between Jonesworks and Wayfair to suppress disclosures concerning Lively's harassment at the hands of Wayfair's co-founder, as well as the company's own role in the ensuing retaliation campaign, while punishing Jones and Jonesworks for cooperating with a legal process that brought those facts to light. This effort is squarely prohibited by the Federal Speak Out Act, and I swear to God, if these assholes exploit that one more time, I'm just going to close this document and go to bed. I'm so tired of this shit. Which precludes enforcement of pre-dispute non-disclosure clauses in matters involving sexual harassment and retaliation. What sexual harassment and retaliation? And accordingly renders the confidentiality clause of the Wayfair agreement unenforceable. Wayfair also alleges that Jones failed to render services in a professional manner and in accordance with Wayfair's goals. Not so. The amended counterclaims themselves reveal that Jones worked tirelessly on Baldoni and Wayfair's behalf to pursue a positive agenda in seeking to counteract negative press about Baldoni. Against everyone's will, by the way, because everyone was basically saying, Stephanie, please stay the fuck out of our business. And she continued to insert herself to the detriment of her clients because she was doing a crappy job. She didn't really know anything about them or their accounts. Okay, she was busy with her higher profile clients, and then she decided to jump in when it was convenient for her. And she did a terrible job. So, all right. One second. Okay. Wayfair's implied covenant of good faith and fair dealing counterclaim fares no better. It is duplicative of its breach of contract claim, premised on the exact same factual allegations, and invents an implied duty that does not exist. Wayfair has not alleged that the agreement was not performed in good faith. Instead, Wayfair has alleged a misguided breach of contract claim, which fails for the parade of reasons set forth above and herein. Under well-settled New York law, a separate implied covenant claim must be dismissed. Finally, Wayfair's new defamation counterclaim collapses under minimal scrutiny. For one, Wayfair's amended counterclaims are bereft of any allegations that the allegedly defamatory statement regarding a smear campaign to destroy Lively's reputation as retaliation for Lively's reported complaints about sexual harassment on set is false. I'm going to hold my tongue. In fact, the amended counterclaims are rife with allegations that confirm the truth of the statement. I fucking hate you. And falsity aside, the purported statement that Wayfair's crusade against Lively was a smear campaign is a quintessential protected opinion, protected under well-established First Amendment principles. Moreover, as a public figure, Wayfair was required to allege that the statement was made with actual malice. It does not, providing yet another basis for dismissal. Wayfair's defamation counterclaim is not only suspect in its tardy unveiling, despite knowing the purported facts underlying the claim as of its first counterclaims, but also fails as a matter of law and is so baseless that it warrants an award of attorney's fees under New York's anti-SLAPP statute. Wayfair's amended counterclaims are not just meritless, they are retaliatory. You want to talk about retaliatory? Really? That's rich. Okay. They are yet another effort at a smokescreen transparently leveraged to shift the limelight from Wayfair and its founders' bad acts. Wayfair breached its contract with Jones Works and participated in a campaign to take down Jones and the business she spent years building. Wayfair must be held to account absent the distraction of faulty amended counterclaims. Its continuing gambit should not be countenanced, and the court should dismiss the amended counterclaims with prejudice. We're getting to the factual background here. Let's see. Written services agreement. We're going to skim over that because we've already seen this stuff. As the premiere drew closer, the premiere for It Ends With Us, Wayfair and Baldoni found themselves in a PR crisis. Whose fucking fault was that, Stephanie? Jesus. With news outlets speculating about possible tension between Lively and Baldoni. Jonesworks employee Jennifer Abel was its point person on the Wayfair account and trusted with the role due to her seniority and experience. Although not running point, Jones regularly participated in meetings, calls, and written correspondence, again, against everyone's will. She was asked to stay out of the account. She was asked to leave it alone. As Baldoni's harassing misdeeds began to appear in the media, Wayfair and Baldoni engaged in crisis PR expert Melissa Nathan. Jones advocated positivity. However, unbeknownst to her, Abel and Nathan were running a shadow campaign for Wayfair and Baldoni to destroy and bury Lively. On August 8th, a Daily Mail reporter told Abel and Jones that she was working on a story surrounding the recent rumors that there was a feud between It Ends With Us co-stars Blake and Justin. Jones received this message after the story was published, but offered to work with the reporter to get this fixed, since she has been very nice in the past. Jones emailed Wayfair CEO Jamie Heath and Baldoni that she left word for the reporter, having returned a missed call believed to be, but not in fact, the reporter's. Jones never called or connected with the Daily Mail reporter. I'm sorry. Jones emailed Wayfair CEO Jamie Heath and Baldoni that she left word for the reporter. And what was it that they said in response to that, Stephanie? What did they say to that? Naturally, Jones' press strategy focusing on promoting positive narratives was not aligned with Wayfair's secret agenda of taking down Lively. Accordingly, Wayfair and Baldoni told Jones to stand down, while Abel and Nathan falsely informed I almost said Joni, that's my mom's name, bro, informed Sony and Sloan that Jones had leaked information and was communicating negatively to media. This was objectively false, as Jones confirmed at the time to Wayfair President Tara Hanks she never leaked any information about Baldoni or Wayfair to the Daily Mail or any other outlet. Nevertheless, falsely accused and seeking to quash the perpetuation of false narratives, Jones naturally contacted Sony to inform them that she did not do so. Well, then, case closed. You're innocent. Throughout August 2024, as coverage of the strained relationship between Baldoni and the It Ends With Us cast mounted, Jones continued to advise Wayfair on a positive approach and a positive approach in navigating the PR fallout, particularly given that, in her view, Baldoni was not being represented in these stories. So they had to fight for every story, as she informed Hanks. You were asked to stay out of it, and you continued to talk to the press. Get a grip. Jones even sent Hanks her phone records to show that she did not call the Daily Mail or any other media source. Well, we know you like to take other people's phones, Steph, so maybe you didn't use yours. I don't know. I'm having a hard time believing that there's no other way you could have done what you did. Consistent with the agreement and the services provided by Jones Works thereunder, on August 14th, Jones emailed Heath a recommended media strategy. Jones proposed, among other things, flooding the zone with positives to ensure that we promote positive narratives that media outlets cannot ignore. And as word of Baldoni's harassment towards Lively continued to spread, including in an August 14th TMZ article titled, Blake Lively felt Justin Baldoni fat-shamed her, kissed too long during scene, Jones offered to contact Harvey Levin, the founder of TMZ, to get the story fixed/removed if Nathan cannot, in furtherance of the goal of working as a team and collectively to tackle the influx of the stories. We've heard all this. All right. Argument 1. Wayfair's breach of contract counterclaim should be dismissed for failure to state a claim. A. Wayfair fails to plausibly allege plaintiffs breached the agreement. Wayfair never states what exactly this purportedly confidential information was. Let's see. What are we talking about here? In its amended counterclaims, Wayfair includes several new paragraphs outlining a purported scheme through which Jones and JonesWorks somehow improperly disclosed Wayfair's confidential information to Sloan, Lively's husband, Ryan Reynolds, and eventually media outlets, including the New York Times, via a lawful subpoena. Oh yeah, put it in bold and italics, because now I believe it's not fucking shady at all. All right. This alone is fatal to its breach of contract claim. Wayfair makes no serious attempt to argue that Jones acted improperly in responding to a subpoena and producing documents. That silence is telling, as not only did Jones act properly, but she was legally obligated to comply. Wayfair's lone assertion of impropriety is that JonesWorks did not provide notice of the subpoena to Wayfair or its representatives. But the agreement contains no such obligation. Having never negotiated nor agreed to such a provision, Wayfair cannot now conjure a truly phantom clause to support its faulty claim. I'm sure that'll look great for prospective clients, Stephanie. Wayfair also baselessly attempts to suggest that Jones disclosed Abel's text messages to Sloan before receiving a subpoena. Other than this conclusory allegation, Wayfair fails to allege what these purported text messages actually contained, when and how they were purportedly disclosed. Are you joking? Is this a joke? How, if at all, they involved confidential information relating to Wayfair, or how messages that support Sloan's purported statements that Nathan could expect to be sued could be confidential information under the agreement. You're leaving out quite a bit there. Her purported statement that Nathan could expect to be sued because I've seen the text messages on your phone. And then also another employee of JonesWorks texted Jennifer Abel and said, that's not what it says according to the text on your company phone. She's been showing that to people. It's not fucking rocket science. Like, Jesus. Instead, the amended counterclaims allege that Wayfair's co-defendant Nathan said that Sloan had told Nathan that Sloan had seen the counterclaims conveniently. The counterclaims conveniently employ passive voice here. Abel's unspecified text messages. Sure. This game of telephone. Well, calling it telephone is a choice. This game of telephone is nothing more than a hopeless speculation, not even purporting to involve Jones or Wayfair directly, and cannot support the conclusion that Jones must have leaked confidential information about Wayfair to Sloan, nor suffice as a plausible basis for a legal claim. Sorry. Let's see. Wayfair also fails to tether any alleged disclosure to the language of the agreement. This is for good reason. The agreement's confidentiality provision is narrowly drawn. It obligates JonesWorks only to use reasonable and diligent efforts to keep confidential information confidential, and expressly permits disclosure to third parties to the extent necessary to fulfill its obligation under this agreement or to its legal representatives. I want someone to look up in her complaint, Stephanie Jones's initial complaint. She's saying that Wayfair owes her money because they were still under contract, right? So I just want to make sure, like, the time frame that we're looking at for, like, when she allegedly just, like, exposed this confidential information without notification is falling within that. So that's crossed my mind, but I need to look at that tomorrow because I want to get through this tonight. Okay. I haven't looked at the chat in a minute, but the first thing I'm seeing here is I've been all up Diddy's butt. So I'm not sure what exactly you guys are doing over there, but behave. Okay? Hold on. Give me a sec. Oh, you gotta be kidding me. Look at that. Okay. We're good. We're good. Sorry, there were 3 new document updates, but it's what we're already looking at, so we're good. I was about to throw something. All right, Wayfair also fails to tether any alleged disclosure to the language of the agreement. This is for good reason. All right, blah, blah, blah. Wayfair's second breach of contract counterclaim alleging that Jones and Jonesworks somehow breached the agreement by failing to follow instruction fares no better. This counterclaim offers no detail about what instructions were... Ma'am. Offers no detail about what instructions were purportedly given, who gave them, when or in what context, how Jones or Jonesworks did not follow them, and how this constituted a breach of the agreement. It seems pretty straightforward to me, but hey, anything is possible when you lie about it. All right. In short, Wayfair's breach of contract counterclaims, even after amended, persist in being devoid of any factual allegations that would support a breach of any enforceable contractual duty. Courts routinely find that claims as these built on speculation, inference, and generalities, alleging a breach not of the agreement, but of vague, ambiguous, and ever-shifting requirements not actually in the contract are not enough. I'm not sure any of that applies there, but okay. B, Wayfair fails to plausibly allege any harm it suffered. Okay. Nowhere in the counterclaims does Wayfair allege any concrete harm stemming from the purported disclosure of unspecified... Is that a fucking joke? Like, what are you doing? This is like the soup can all over again. I feel like I'm being railroaded. What is happening? Let alone the disclosure of any such information. The amended counterclaims do not identify a single news item containing any allegedly harmful information. They do not... Well, that's not true. They do not allege how any content was purportedly false, damaging, disseminated, or even traceable to Jones or Jonesworks. Am I high? Like, what am I missing here? Because this is not making any sense. Because all of that was clearly laid out. And Wayfair does not allege any actual consequence, financial, reputation, or otherwise, suffered by Wayfair as a result. Again, what planet am I on? Instead, Wayfair relies on inference, built atop inference, that Jones or Jonesworks must have been the source of some unspecified harm simply because they complied with a lawful subpoena, and that this harm must have flowed from a contractual breach. But courts routinely reject damages that are not capable of proof with reasonable certainty. Allegations as these, grounded in conjecture, speculation, and post hoc assumptions, cannot substitute for facts, particularly where the claimed harm involves media narratives and third-party conduct, factors well beyond the party's contractual framework and outside the scope of Jonesworks' obligations. Even more telling is what Wayfair does not allege. It does not claim lost revenue, lost opportunities, increased costs, reputational decline tied to specific events, or any other identifiable economic or actual injury. These omissions are just positive. Ultimately, in addition to the amended counterclaim's failure to plead how, when, or where any alleged disclosure might have occurred, Wayfair has also failed to allege any facts connecting a supposed disclosure to any cognizable harm. That failure is independently dispositive. See, the Speak Out Act bars enforcement of the confidentiality clause. Well, I'm not going to read this section, guys, because there was no sexual harassment that took place, so I'm absolutely not going to fucking read that. I'm done. I'm done reading that. D, Wayfair has not alleged a material breach. I will read it. Okay, I will read it, but I'm not reading it right now because I'm going to swear a lot, and I'm just going to move on for the live stream. I'll read it after. Wayfair has not alleged a material breach excusing its own performance. Under New York law, a party must perform under a contract. Their performance is excused only where the other party has materially breached the agreement. That is, where the breach is so substantial that it defeats the object of the parties in making the contract. Okay. To sufficiently excuse their non-performance, the party must allege specific facts of the material breach and the excuse. Wayfair did not plead a material breach on Jones or Jonesworks' behalf, excusing it from performing under the agreement. Wayfair merely claims that it advised Jones that they were terminating the Jonesworks agreement as of the end of August 2024, and follows with the conclusory allegation that this was justified and excused due to Jonesworks' material breach. First, this is a quintessential example of a bare bones allegation of simply the legal standard, which is routinely disregarded as insufficient by courts. Second, as discussed, supersection 1.a, the amended counterclaims do not, because they cannot, plead a material breach of the agreement on Jonesworks' part that would excuse Wayfair from performing. Failing to allege any concrete instances of purported conduct warranting non-performance, which under no construction could be alleged to constitute a breach, defeats any claim by Wayfair that they were aware of any, let alone had sufficiently pleaded any, breach substantial enough to justify immediate termination. Wayfair cannot retroactively manufacture a material breach based on speculation or events allegedly discovered later, or to justify improperly leaving Jonesworks to jump ship to Abel's new firm. Okay. So your butt hurt. Got it. In reality, Wayfair itself breached the agreement when it claimed to terminate without complying with a notice and cure provision requiring Wayfair to provide Jonesworks with notice of any breach and a 10-day period to cure such breach prior to terminating the agreement. One sec. Oh, hey, Steph. What's going on? Lauren has been nibbling on chocolate brownies. I have not. I have not. Okay. I'm looking at one of Steph's comments here. Natalie says, since the other actresses haven't said anything and her smoking gun might just be her sister who was an extra on set. The whole family says. So yeah, I'm assuming her sister is going to be one of those people, right? But then also, when they're saying we have other witnesses who will come forward, that doesn't mean they have other witnesses who are going to come forward and say, oh, yes, this man sexually harassed me. I mean, they might just have witnessed, some things they're asking about. They might have witnessed a heated conversation or something. They might have witnessed, I don't know, them acting a scene in character that she's going to allege in question, or put into question, like whether or not he was doing what he was supposed to per the script and stuff like that. That doesn't mean that they are coming forward to say, like, he definitely did this. So they're just being sketchy in the way that they're wording things in the press right now. So I'm not for it. Okay. Wayfair's counterclaim for breach of the implied covenant of good faith and fair dealing must be dismissed as duplicative of its breach of contract claims. Okay. We're going to skim through a bunch of this stuff. Wayfair's defamation counterclaim must be dismissed. Wayfair's new defamation counterclaim, which is inherently suspect, Hey, sorry about that. No, StreamYard, the whole StreamYard website, which is what I use as a streaming service, crashed. So I'm back now. Hang on, let me pull this back up. And we'll have to get a reminder of where we were. But we're almost at the end of it anyways, but give me one sec. She'll return. I swear to God, she's really stubborn. Hello, I'm back. Okay. Let me see. Where were we? Wayfair's defamation counterclaim must be dismissed. Wayfair's new defamation counterclaim, which is inherently suspect given that it is based on alleged facts well known to Wayfair at the time of its original counterclaims, unsurprisingly also fails. To state a defamation claim, public figures like Wayfair must show that the statements it complains of were 1, of and concerning the plaintiffs, 2, likely to be understood as defamatory by the ordinary person, 3, understood. 3, false, and 4, published with actual malice, that is, either knowledge of falsity or reckless disregard of the truth. Here, Wayfair falsely alleges a single allegedly defamatory statement on information and belief. Jones reportedly told Sloan on August 21st that Wayfair, along with Abel and Nathan, had orchestrated the malicious smear campaign to destroy Lively's reputation as retaliation for Lively's purported complaints about sexual harassment on set. Wayfair's claim does not plausibly allege that the challenge statement was factual, false, or published with actual malice. This counterclaim must be dismissed. All right. The alleged statement is constitutionally protected opinion. First, the alleged statement that they engaged in a smear campaign is a constitutionally protected opinion that, under both New York and federal law, is not actionable as defamation. Okay. Because statements of opinion cannot serve as the basis for a defamation claim, Wayfair's claim must be dismissed. B, Wayfair fails to allege that plaintiffs made a false statement. Second, Wayfair does not allege facts supporting a conclusion that the alleged statement was false. Here, Wayfair alleges no facts as to how the alleged statement that Wayfair had engineered a retaliatory smear campaign against Lively was false. Absent any allegations as to this essential element, all that is left is an unadorned, the defendant unlawfully harmed me accusation claim that must be dismissed. And what is more, Wayfair's own counterclaims established that it was, in fact, engaged in a smear campaign against Lively. That is not true. Jesus Christ. Whoever wrote this was high. And not in a fun way, in a spinning out of control way. No, I'm just kidding. Mostly. For example, Wayfair concludes that on the eve of the It Ends With Us premiere, media was reporting tension between Lively and Baldoni. Those reports demanded immediate crisis PR expertise from Nathan. Wayfair even admits that people in its circle held Lively in deep disdain. Well, yeah, that doesn't mean they established a smear campaign against her, and regarded her self-immolation with a degree of schadenfreude, which was the natural result of the Wayfair party's firsthand knowledge of Lively's vicious behavior and malignant persona. Yeah, that doesn't mean what they're trying to say it means, but, go off, I guess, if you have nothing else. Taken together, those allegations admit the core of the alleged statement. Wayfair executed a coordinated media offensive to discredit Lively. No. Honey. Even by its own telling, Wayfair marshaled crisis PR resources and harbored overt hostility towards Lively, all fully consistent with the alleged description to Sloan. Fuck off. C, Wayfair fails to plead that plaintiffs acted with actual malice. All right. First, Wayfair sought public attention to influence public opinion, including by acquiring the film rights to Hoover's best-selling novel. So they're just establishing that Wayfair is a public figure. Okay, so we're going to skim through this stuff. Wayfair's counterclaims fall far short of alleging actual malice, i.e. non-conclusory facts establishing that Jones was aware of either the falsity or probable falsity of her statement, or acted with reckless disregard of its truth or falsity. Okay. Plaintiffs are entitled to attorney's fees under New York's anti-SLAPP law. Okay. New York law requires that costs and attorney's fees shall be recovered upon a demonstration that an action involving public petition and participation was commenced or continued without a substantial basis in fact and law. Wayfair's defamation and counterclaim qualifies. It involves public petition and participation. Wayfair's defamation counterclaim was also commenced without a substantial basis in fact or law. Wayfair's threadbare claims of defamation, not only as stemming from the alleged statement in paragraph 55, but also as stemming from various other unspecified phantom statements, plural, as baselessly asserted in paragraphs 88 to 94, are legally and factually insufficient, and a finding that an action was commenced without substantial basis in fact and law is certainly triggered by the failure to state a claim. All right. For the foregoing reasons, plaintiffs respectfully request the court dismiss Wayfair's counterclaims with prejudice. All right, we did it, guys. We're done. It took less than 2 hours this time. All right, hang on. Yeah, I'm gonna go to bed now. I think, unless Omar's doing something, but I don't think he is. It's already past midnight, bro. Okay. Yeah, I'm gonna take off. I'll see you guys tomorrow. Like I said, I'm going to do a short recap of this tomorrow morning. So if you didn't catch all the live and you don't have time for that shit, that's fine. I'll do a shorter one tomorrow. So, okay. I'll see you later. It's no wonder I will get back to you on that. All right. Thanks. Bye. Thanks guys. Bye. I need to sleep. I need sleep. I need to go to sleep. Goodbye. Wait, no. Just Ricardo, thank you for the 2 money for the speak out vomit bucket. Thank you. Okay. Now I'm going. Thanks, Ricardo. Bye.